Hello and welcome to Courts Today by Live Law. Let us start with today's top headlines. The Supreme Court has held that caste-based insult in backyard of private house does not come within public view and is no offence under Section 3 of the SC/ST Act. In a motor accident which left a 7-year-old girl mentally disabled, the Supreme Court has now enhanced the compensation to 50 lakhs. The Supreme Court is set to hear a plea filed by the Competition Commission of India seeking transfer of petitions filed by Amazon and Flipkart against its previous investigation order. The Allahabad High Court has said that judges must continue work even during lawyers' strike. It has asked police protection to be provided to litigants if they wish to argue. And the Bombay High Court has held that in-laws keeping young child away from mother in defiance of the court's order is cruelty under Section 498A of IPC. I am your host Urvashi Chauhan with your daily roundup of legal developments from across the country. Before moving ahead, let me tell you, Live Law Academy is offering a value-packed opportunity for aspiring judges. The Judicial Service Examinations Preparation Course. This comprehensive online course is designed to help you prepare for your judiciary exams. Classes are conducted by expert faculty, including retired judges, and you would learn from actual case studies and other easy-to-follow study materials. And all of this comes at a very affordable fee. If you are gearing up for the judiciary exams, this is a must-check opportunity for you. Enroll today and get 25% scholarship. You can check all the details at www.livelawacademy.com. The link is also provided in the description. The Supreme Court has ruled that caste-based insult or intimidation occurring in the backyard of a private house does not meet the criteria of being within public view under Section 3 of the SC/ST Prevention of Atrocities Act of 1989. In this case, the complainant, accompanied by her employees to carry out repairs on her adjacent property, entered the appellant's backyard without prior permission. The appellant objected to the entry and allegedly made insulting or intimidating remarks. A case was then filed against him under the SC/ST Act with the complainant's stand that the actions of the appellant were driven by caste-based discrimination, which fell under the purview of Section 3 of the SC/ST Act. In response, the appellant filed an application for discharge, arguing that the incident did not meet the criteria of public view under the Act. But the additional sessions judge in Bhubaneswar rejected his request, leading him to move the High Court. However, the High Court also upheld the rejection, and so he appealed before the Supreme Court now. The appellant argued that the incident took place in his private backyard. He also highlighted a pending civil dispute between his wife and the complainant's family and contended that the charges against him were baseless. The state opposed the appeal, pointing out that the trial was already progressing, with 3 out of 6 witnesses having testified. They urged the court to not interfere at this stage. After reviewing the case, the Supreme Court concluded that the backyard of a private residence cannot be considered a place within public view and that the individuals involved in the incident were not part of the general public. As a result, the charges against the appellant were not sustained under the SC/ST Act. In another update, the Supreme Court has awarded 50 lakhs 87,000 as compensation to a claimant who suffered severe mental and physical disabilities due to a motor accident in the year 2009 when she was just 7 years old. The tragic accident occurred when a high-speed car driven negligently struck the young girl as she crossed a zebra crossing with her mother and brother. She sustained head injuries that resulted in moderate mental retardation and impaired mobility. Initially, the Motor Accidents Claims Tribunal had granted 5 lakhs as compensation in 2009, which was later enhanced to 11 lakhs by the Delhi High Court in 2017. Dissatisfied, the claimant appealed to the Supreme Court, which has now increased the compensation to more than 50 lakhs. A bench of Justices B.R. Gavai and K.V. Vishwanathan took into consideration the deposition of a doctor who stated that the victim's condition limits her to the learning skills of a second-grade child and requires her to live under adult supervision for the rest of her life. While the disability certificate rated her disability at 75%, the court ruled that her functional disability should be considered 100% for practical purposes, given her lifelong dependency. The compensation now granted by the Supreme Court was given keeping in mind the loss of income, for pain and suffering, loss of marriage prospects, medical charges, and for attendant charges. The Supreme Court is going to consider the plea filed by the Competition Commission of India seeking transfer of writ petitions filed challenging the probe against e-commerce giants Amazon and Flipkart. So back in January 2020, in a setback to Amazon and Flipkart, the Competition Commission of India had directed the Director General to probe the allegations of a violation of Competition Act by these e-commerce companies. This order was passed by the Commission on a prima facie finding that they were giving undue promotion to some sellers over other small sellers. Amazon and Flipkart have filed various writ petitions challenging the CCI order in various high courts. And CCI has filed a transfer plea in the Supreme Court seeking the transfer of these 24 writ petitions to itself or the Delhi High Court in order to avoid multiplicity of proceedings. Today, Attorney General R. Venkataramani mentioned before a bench led by CJI Sanjeev Khanna the urgency of hearing the transfer pleas before 17th December as the Karnataka High Court is scheduled to hear petitions filed by Amazon and its sellers on that date. Responding to the request, CJI Khanna clarified that the matter has already been marked for hearing. And now let me tell you, the Allahabad High Court has expressed strong concerns over litigants being denied justice due to ongoing lawyer strikes, despite the availability of statutory remedies. Justice Ajit Kumar, in a strongly worded order, observed that litigants are being forced to approach the High Court for relief as district courts remain inaccessible during lawyer strikes. The court stated that this situation undermines the judicial system and deprives the citizens of their right to justice. While hearing a writ petition filed by one Ashutosh Kumar Pathak challenging an order granting release in favor of a landlord under the UP Registration of Urban Premises Tenancy Act, Justice Kumar noted that the petitioner could have filed an appeal under the Act. However, the petitioner's counsel argued that doing so was not feasible as lawyers in Ghaziabad were on strike, leaving him without legal representation at the district level. Justice Kumar then emphasized that judicial officers must perform their duties regardless of lawyer strikes, ensuring that litigants have access to the justice system. He said that lawyers belong to a noble profession and should not obstruct litigants or judicial officers from carrying out their functions. He also said that no litigant should be left without remedies because of disruptions caused by lawyer strikes and directed the district administration to provide police protection if litigants wish to argue their cases themselves. And lastly, in a significant ruling, the Bombay High Court has held that keeping a minor child away from the mother in defiance of a court order amounts to mental harassment and cruelty. A division bench of Justices Vibha Kankanwadi and Rohit Joshi refused to quash an FIR against the in-laws of a woman after noting that her husband, the main accused, had been absconding. The husband had also taken along with him his 4-year-old daughter, despite a clear order from a family court to hand over the child's custody to the woman's mother. In the complaint filed by the wife, she had said that the husband demanded 10 lakhs for purchasing a car, and when the wife's family failed to fulfill the said demand, he ill-treated her and even assaulted her. She alleged that her in-laws, including her sister-in-law, too abused her for not fulfilling the demand of the husband. The bench here was hearing petitions filed by the parents-in-laws and the sister-in-law of the woman to quash the FIR lodged against them. The bench noted that the in-laws failed to spell out the whereabouts of the main accused, that is the husband, who absconded along with the minor daughter, defying court's order to hand over the custody to the mother. The bench also refused to accept the argument that the sister-in-law was a specially abled person suffering from schizophrenia. Thank you for watching. For more information on the cases that I mentioned, you can visit our website at www.livelaw.in. Your support means the world to us. So please do not forget to like, share and subscribe to our channel. You can also support us by clicking the thanks button below our videos or by becoming a member for just 89 rupees per month.